The justice system has to be malleable, and it has to adapt itself to the situation. George Washington would never have found himself in this situation, and we haven't had a president of the United States in all our history who has been charged with 91 felonies and 4 indictments in 4 different courts, 2 state, 2 federal. And the justice system will just have to learn to cope with it, and they will cope with it.
Don't you think that it'll be different when he's at a trial where there's a jury, that the judge will be more careful there to make sure that this doesn't happen, if he takes the stand even? I mean, this is a civil trial, so he had to take the stand when called by the Attorney General's office. But in a criminal case, he may not take the stand, and I think that the judges will be stricter when there's a jury there.
I think the judges will be stricter. And, in mafia cases, we've had unruly defendants who have made comments when they did not take the stand, and the judge actually gagged them in front of the jury. And so there's precedent, not only for a gag order, but for gagging him so they can't interrupt the proceedings. He has to have respect for the proceeding.
And while that's true, I think they also need to, politically for themselves, for Letitia James, for any of the elected officials there, need to show a little bit of deference to a former president, don't they? Even if he's not popular in New York City, he's
a private citizen like any of us. The office he once held demands very high respect. He's not comported himself in a way that goes with the word respect. I mean, he's been irrational. He is engaged in these harangues against court personnel, against prosecutors, all to serve his own political ends. And the justice system will reach a point where it won't tolerate it.
Well, and I wanted to ask you about something just a little bit different. The collision between the political calendar and the trial calendar. Eileen Cannon down in Florida on the documents case, which actually seems to be the clearest of all the cases, she's now sounding amenable to maybe delaying the trial beyond May, maybe even giving in to Trump's request that it be after the election. What would be your take on how that would work, and how would it change the case legally if he were tried after the election and won?
Well, assuming he won the election, all these cases would disappear because he would either pardon himself, which means the end of all the federal cases, or he would direct his attorney general, since he's already said that if he gets in, he's going to have a politicized Justice Department, and he'll direct his attorney general to drop the cases, and they'll drop the cases. So that's what he's banking on. This New York civil case is one of the most threatening cases because it may strip him of his net worth and prevent him from conducting business in the state of New York.
Well, let me ask you this about the other cases. Is that why it's important that the Georgia case go forward? Because that would be a state conviction, and he couldn't pardon himself from that.
He could not pardon himself either from the Georgia case or from Alvin Bragg's Stormy Daniels case in New York.
I was avoiding that one on purpose
because
it's the weakest of the cases.
I don't know that it's the weakest. The false statements are very clear. The question is, can it be enhanced into a felony? And I think
That's
it can.
weak.
But that is the weakness. However, it's true, we can't pardon those offenses, but there's no way that a local prosecutor is going to bring to trial a sitting president or even a president-elect. It's just not going to happen.
There is some room, though, because the trial that was supposed to go forward a couple of weeks ago, they all pled out on that. So now there's some room in that calendar, perhaps, to bring the case earlier.
There is, but no trial date has been set. And I think if a trial date is set, you're going to have other defendants who will plead guilty. And the defendants who remain are going to be Trump, Giuliani, Mark Meadows, maybe one or two others. It'll be a very manageable trial, and it can certainly occur before the election. The real problem is that if he's convicted of all these indictments, he's still qualified to be the President of the United States. Why because the framers of our Constitution never dreamed that there would be a president or a candidate for president like Donald Trump. Lawless, contemptuous, disrespectful of the rule of law. He is a rogue candidate. He would be a rogue president. He said if he gets in, he's going to terminate the Constitution to stay in office. He said he's going to weaponize the Justice Department to get at his political enemies. We've never had that before. And our Constitution, which was framed in 1789 and the amendments in 1791, are just not geared to deal with it. The one hope of disqualifying him, unless the Republican Party wakes up and decides not to nominate him, the one hope of disqualifying him is the case in Colorado and Minnesota, where voters have brought cases, as they have actually in 21 jurisdictions, to disqualify him.
But those cases are real uphill battles. There are so many different issues there that the plaintiffs have to win in order to win those cases. Do you really see those cases as stopping him from being on the ballot?
I see those cases as going to the Supreme Court, because if just one state holds that he's disqualified, the Supreme Court is going to have to make a decision as to whether Section 3 of the 14th Amendment to the Constitution disqualifies Donald Trump. And they don't have to find that he physically engaged in the insurrection by force. The history of the 14th Amendment shows that people have been disqualified based on speech. The simple statement that he plans to terminate the Constitution if he gets in office, in order to stay in office, violates Article 2 of the Constitution and violates Section 3 of the 14th Amendment. I don't think it's an uphill case, because there are a lot of issues that have been raised.
Well, the weight of authority says it's an uphill case. I mean, there hasn't been a case at that level, at the appellate level, at all. It's an open question, an open constitutional question that the Supreme Court, as you say, will have to decide.
That's true. It's an open constitutional question. It's an open constitutional question as to whether he has blanket immunity from crime for everything he did in office. He claims he does. The Supreme Court has never passed on that. But it would seem to me that the logic of the Constitution is that he does not have blanket immunity.